Welcome back, students. Today we're going to look at judicial interpretation of the Constitution by the U.S. Supreme Court. This will be related to both chapters 4 and 5 of your textbook and the cases that are related to those chapters in the second part of your textbook. I thought about doing this, and I think it's a good idea. Although the focus of this course is not totally upon how the justices think when they basically interpret the Constitution, but it is an important part of it, because I think it will help you once you understand it, to understand why there are such differences sometimes in looking at the same set of facts by similarly schooled and very intelligent people dealing with those issues that can come out to two contrasting opinions in both the deciding opinion of the case opinion itself, and the various dissent or dissents in the case. And that sometimes comes down to simply a matter of how the individual justices interpret the various provisions of the Constitution, both the major Constitution and the Bill of Rights section of it, when they are interpreting factual questions that have made their way up under the questions of law involving those factual questions, have arrived at the Supreme Court. And remember this, that they arrive there discretionally, and the Supreme Court has issued the writ of certiorari to bring the cases up, because 4 justices on the court felt that the cases not only presented a constitutional issue, but one that was appropriate for the Supreme Court to hear and decide. So let's look at these basic schools of thought as to how a Supreme Court justice interprets the U.S. Constitution. Now, if we look at the history of the Constitution itself, and of the Supreme Court, actually, of the Supreme Court, actually both the Supreme Court and the Constitution. After the Constitution was drafted, there was not debate over how the constitutional provisions should be interpreted by the Supreme Court. This did not really arise till later in the court's history, predominantly after Chief Justice Marshal in Marbury versus Madison. He actually seized on the right of the Supreme Court to review acts of Congress. As Chief Justice said, it is basically, as paraphrasing him, but he basically said that it is the court's job to decide what the law is. In making that assertion in Marbury versus Madison, he staked out a clear position that the Supreme Court would be a reviewing authority, although there were many contrasting opinions at the time as to the powers of the individual components of our government and the powers of the state governments in regard to how the Constitution should be interpreted. But Marshall's position in Marbury versus Madison set the stage for the development of the court as a true third party of government, when he said that the court would review and had the power to review the acts of the Congress. Chief Justice Marshall was a strong nationalist, and he was a Federalist. He believed that the national government, to strengthen it, was important, because he firmly believed in the world as it was then. To have states with equal power, it would lead to so many problems that the United States as a whole would have a hard time surviving. And that political concern of the Chief Justice certainly underlied his methods that he used, and his theories that he might have applied in interpreting the cases that he had to decide as the Chief Justice of the Supreme Court. Now, during that period, Marshall generally comes under the school of thought that is commonly called today as the declaratory school. And this school basically was based on Blackstonian theory as exposed by Judge Blackstone in the English common law system. And it was that the theory basically was that the judges declared the law. They were not someone who was creating the law, but they were declaring what the law was. And this declaratory theory still had to rely upon how did they know what the law was. And in looking at a constitution, the way that Chief Justice Marshall would have said that he looked at the Constitution was he tried to find the plain meaning rule. What was the plain meaning of the Constitution? How someone would commonly understand the phrases, the words used in the Constitution, and would have a basic understanding of the structure that the framers wanted the Constitution to have to carry out the mission of the Constitution as they saw it. And with Marshall, he did not feel the framers would have accepted the idea that judges should be able to overturn the plain meaning of the words. Now, plain meaning is not the same as the meaning that an individual jurist might decide to give to the text of the Constitution. It was the commonly accepted meanings that people at the time that the Constitution was written would have assumed that the words that were used meant. This basic plain meaning school of thought did not give rise to a lot of debate over the interpretation of the Constitution. Where the major debate was at the time was just this idea that the Supreme Court had seized the right to interpret the Constitution. Their basic methodology that they were using was not as strong an issue as just the fact that they were interpreting the Constitution. And they were challenged on this. But under Marshall, it was probably maybe they actually normally regarded as the greatest Supreme Court justice in history. His mental abilities, writing abilities, and his political knowledge enabled him to steer the court in a direction that maintained its strength and actually was very much responsible for the growth and the security and the eventual strength of the United States of America. In the late 19th century, we started to see a change in the interpretation, and the court started to look at the Constitution, at least individual justices looked at it, as that it wasn't just the law's job. Their job was not just to serve as a spokesperson for the Constitution. That the Constitution was actually, that their interpretation of the Constitution was greater than that. And in fact, they were not just declaring the law, but they started to recognize that they were in fact actually creating law. And that change in the perspective really kind of set the framework for what we still see today as the issue between just saying what the law is versus actually interpreting the Constitution in ways that you could say that the court has actually created law through their judicial opinions. Justice Holmes was probably the greatest spokesperson for the idea that judges did more than just declare law. His famous statement that the life of the law has not been logic but experience, meant that the judges did not function as just taking a set of laws and principles and declaring what the result should be. that their experiences in life and the experiences of the country itself as it changed, all were factors in how the law was being interpreted and actually carried forth through the opinions that were made by the Supreme Court. Another justice, very prominent in the early 1900s, Roscoe Pound, basically believed that judges should actually mold the law through the needs of the society. And Pound was not a judge, actually. What Pound was the dean of the Harvard Law School. He was a noted legal scholar at the time. So he really was proposing a theoretical approach for the justices to take on the Supreme Court. This basic viewpoint really took root as far as basically applying. It became what's often called the living Constitution theory, that the Constitution changes with the times, that the judges can rely upon more than just reading the text or reading some of the documents or the hearings at the time. That they actually had to interpret in a way that was congruent with the changes that were going on in our society at the time, where they were faced with factual questions that involved more than just a simple knowledge of the text of the Constitution. There is no doubt that judges, in effect, often create law through decisions. They can do this by striking down provisions within an act that they're deciding upon. They can interpret acts in a certain way. They can actually set forth basically the procedures that people should take place to stay within the Constitution. And so today, I'd have to say we have two broad branches of how we interpret judicial opinions. One school of thought is called the InterpretiveISM point of view, which is based on an idea of originalism. They try to look at the original document, both either the text or the intent of the framers at the time. Some jurists will look purely for the most part, at the text. Other jurists might say that the major focus should be on trying to ascertain what was the intent what did the framers intend when they drafted the actual Constitution. This school of thought basically will always start with an analysis of the document itself, looking hard at the meaning of each word, and if known, trying to basically come to basic conclusions about the actual intent, and using that to frame their own decision making in the decisions that they reach, the conclusions that they reach. The second basic area of thought in how you should interpret the Constitution is called the non-interpretivism school, or sometimes again the living Constitution approach, in which basically the court, a justice who would believe in this basic school of thought goes beyond he will go beyond the text of the document. In fact, that would be part of his methodology, that you would have to take a lot of different aspects of society into thought, the historical context of when it was framed, later, the current time. You'll see some reliance upon modern theories involving psychology, sociology, political science. You're going to see a lot more involved in their decision-making approach, and their living Constitution idea is based really on the fact that political reality really means that in deciding these cases, it takes more than just looking at the original document as it was written, and trying to maintain your decision making within the bounds of that original meaning, or the basic intent of the framers at the time. as opposed to trying to craft decisions that basically were in accordance with dealing with the problems we face today and the way our society has evolved. There's some other factors in our decision making. Not only these two basic schools of theoretical thought, the other areas are more basic. One is the rule of stare decisis. Either school of interpretation believes and practices that the stare decisis rule is that prior decisions should be respected, and you'll see that they will do that, although the jurist, it doesn't say they have to follow prior decisions, but you certainly have to give some weight to prior decisions, and they are averse normally to overrule them, but they do. And again, you'll see this is more easily done in most cases by the living Constitution scholars on the bench that really believe that things have changed significantly, that prior decisions need to be overruled and new decisions have to be arrived at. This can also happen to jurists who are of the interpretivist school, but what you ought sometimes see in those circumstances where they will overturn a prior decision going outside of respect for stare decisis and based on what they saw as an erroneous interpretation of the original intent or the original text of the document. So stare decisis is a principle, though. They start with the idea that look at the prior decisions closely. It's generally a good idea to try to follow decisions. They should be respected. They should not be discarded just willy-nilly, but they certainly can be. And under either schools of thought, even though stare decisis is certainly a rule of analyzing Supreme Court decisions, it is not a decisive rule. It means that it can be easily, it is disregarded by the justices. Let's look at, now looking at these two schools and how the justices look at cases, now let's look at the Fourth Amendment. Because I think it's a good example of how this thought process works. In chapters 4 and 5 of your textbook, and especially 5 where you're going to see police surveillance cases as integral to the Fourth Amendment, you also see the Fourth Amendment generally not just for arrests and seizures, but also for the searches. When we look at this, and we have to look at the way that amendment has been interpreted, because it's been important over a period of 50, 60 years. We've seen various shades of interpretation of an amendment that on the face of it doesn't seem like it would be overly difficult to interpret, but in fact it is proven to be in some cases. The Fourth Amendment itself, the cases that you should understand that are good examples of changing interpretations of the amendment will be first the Olmstead Case. The Olmstead Case, prohibition case, decided in 1928, involved a wiretap where the prohibition agents had actually wiretapped a junction box, on a pole outside the house. The wires came out of the house. They were basically, they were inside the house engaged in alleged criminal activity. And when they did this, tapping the junction box, actually this was against the law of the state, by the way, that they were in. The state had a specific provision. You could not listen in on telephone conversations. But these are federal agents. When the case came up through the federal system, it was apparent they did not have a warrant under the Fourth Amendment. They were basically operating in an area that they felt was outside the boundaries of the Fourth Amendment. And in fact, when the Supreme Court looked at this case, That's exactly what they decided, that the Fourth Amendment did not apply. That the Fourth, and this was Chief Justice Taft, a former president, not a Chief Justice of the Supreme Court. He was a strict constructionist of the Supreme Court, of the Constitution. He was an originalist. Had great respect for textual doctrine, and when he looked at this, in his analysis of it, the Fourth Amendment protected places. It was based essentially on a trespassery doctrine, that when you went into an area that would be a trespass into property, that sprung the protection of the Fourth Amendment up. What he felt that, since his analysis of that was that the Supreme Court, that the Constitution did not have language that would lead itself to apply to a tap, taking a tap outside the protected zone of the house in public property. So he believed that you had to have the actual trespass for the Fourth Amendment to be involved. So there was no Fourth Amendment violation, and the information that the police gained came into the case, and Mr. Olmstead, his conviction was, actually had reversed. He ended up being convicted. There was a strong dissent in the case. That was by Justice Brandeis, and he originated the idea of the court under the Fourth Amendment should be looking more at a privacy aspect, what the individual perceived as being private, not so much, not just where the person was. He was not, and he did not like the trespassery doctrine. He wanted a broader reference for the privacy interests that he saw in the Fourth Amendment. Then, almost 40 years later, we had the Katz case, Katz versus the United States. Again, this was the FBI, gambling case, wagering information in a public phone booth. They put a recording device on top of the public phone booth. They did not intrude into the interior. And again, we did not have a warrant. They thought that basically under the Supreme Court, prior to Supreme Court interpretations, it was not necessary because there was no trespass into someone's actual protected area. Now in the Katz case, what the court decided that they reversed, basically, well, Katz had been found, he'd been convicted. They reversed the decision of the lower court in this case, and they decided that the Olmstead doctrine, the Olmstead decision was basically overruled. It was not applicable. They did not want to rely upon areas as being the protected concept, and that what the government had to look at really was what were the reasonable what was the reasonable expectation of privacy that someone would have in their own privacy, and if that area was going to be invaded, then they were going to need a warrant from a court. And in the Katz case, they felt that Mr. Katz had an expectation of privacy in his conversation, and that it wasn't where he was at, it was his conversation. So based upon that, they felt that the Fourth Amendment should apply, and that a warrant would be necessary to capture that information that would be basically available to to the government without a warrant. In this case, it was necessary to get it because they were violating his particular Fourth Amendment rights. In the balance of the interest there, it came down on the side of the defendant, and that changed the way we look at Fourth Amendment law. Now, since then, you often hear the phrase, and most of the cases are routinely decided on the idea that was this an expectation of privacy? Was it reasonable? Was that expectation reasonable? If so, then the Fourth Amendment applies, and except for exceptions to the warrant rules, normally you're going to have a warrant. This changed again with, now before I go back, after the Katz case, we had changes in the whole idea of electronic communications, because the court also felt that this type of expectation is privacy interest in speech, communications that were basically going over the lines, going by electronic types of communications, wire communications, that they actually needed a specialized form of protection, kind of what was often called a super warrant, and that led to the passage of the Title III Act by the U.S. Congress and similar acts by most of the states, which laid out a specific set of very, very rigid types of requirements if you're going to intrude into somebody's expectation of privacy in the area of communications involving electronic communications. But the latest case is the U.S. versus Jones in 2012 involving a GPS search. And in this case, Justice Scalia, who is an originalist, he went back to the actual text of the Fourth Amendment and felt that although the Supreme Court had been allowing the use of beepers on cars, finding that without a warrant, finding that they did not involve someone having an expectation of privacy, Scalia in the U.S. versus Jones, and remember this is a GPS, not a beeper. What he looked at, what I feel applies to either. He basically felt that a vehicle, in this case, that even though the vehicle was attached to the underside, and in prior cases involving beepers, that had been found not to be a protected area, and that you wouldn't have an expectation of privacy in having that done. In this case, Justice Scalia decided that was really a vehicle was in fact a thing. It was protected under the Fourth Amendment, and by touching it, you were actually intruding into a protected area, a protected zone. And once you've had this trespassory activity, at that point you have a Fourth Amendment interest. Now, Justice Scalia also believed that you could still use an expectation of privacy test, but he believed that the first or primary or the original thing that you would look at in regarding the Fourth Amendment was there a trespass? If there was a trespass under the doctrine as espoused by Scalia in regard to Fourth Amendment applications, once that trespass takes place, you have a Fourth Amendment interest, and you're going to either need a search that is reasonable. You need a search that is reasonable, and in a lot of circumstances, you're also going to need a warrant. In this case, since it was the type of technology that was being used, that you're looking at Justice Scalia believing that in this type of police surveillance, you're going to need a warrant, and it is a Fourth Amendment violation if you don't have one. So that changes some things. There was kind of another offshoot of this with Justice Scalia on a dog search just recently handed down, where bringing a dog onto property to the front door to sniff around the front door, Justice Scalia again applied the same concept of trespass and found that the police had trespassed into this area, and that meant it was a Fourth Amendment violation. And although dog searches are constitutional, generally, if there's a trespass involved with it, then the search is not. You needed a warrant. So that's a big change. So this is kind of how you can see the changes that we have now, based upon how a justice might interpret the constitutional provisions themselves. Remember that in regard to electronic or police surveillance and electronic measures and different types of police surveillance, we have two specialized statutes that have been created. Title III, involving domestic law enforcement generally, and those basically handle wire and electronic communications, oral also. Then you have the FISA Act, the Foreign Intelligence Surveillance Act, which is designated for a very specialized form of surveillance utilized in investigating espionage and terrorism. And those cases have a specialized court, even different provisions, but be aware that we do have legislation enhancing generally the general Fourth Amendment requirements for most warrants and making them a little more onerous in regard to certain specialized areas of government activity. I hope that helps a little bit when you look at these cases, and it is important to try to say, where is the judge coming from? Where is that Chief Justice, or where is that dissenting justice? Where are they coming from when they are interpreting the U.S. Constitution? Thank you.